Okay, let's go on the record. The commission will come to order. Today's date is July 12th, 2013. This is the time and place for the pre-hearing conference for Phase 2 of the Order Instituting Investigation regarding the San Onofre Nuclear Generation Station Units 2 and 3, otherwise known as SONGS. The proceeding is I-12-10-013. I am Melanie, and to my left is Kevin Bagley. We are the assigned administrative law judges in this matter, and Commissioner Florio is the assigned commissioner. This PHC is being webcast for the benefit of customers throughout California. There will be no individual audio taping or videotaping as is set forth in our July 1 order. The OII was initiated under the authority of Section 455.5 of the Public Utilities Code, which authorizes the Commission to eliminate from rates the value of any portion of any electrical generation facility which, after being placed in service, remains out of service for 9 or more consecutive months. Further, the Commission may disallow O&M or operation and maintenance expenses related to that facility. Phase 2 will address this specific authority to remove from rate base the value of SONGS plant in rate base and associated operation and maintenance expenses. Our July 1 ruling set forth a tentative scope of inquiry in this phase and stated that the scope and schedule for Phase 2 would be discussed at this pre-hearing conference. In addition, we will identify whether there will be any new parties or changes to the service list. Commissioner Florio, do you have any opening remarks this morning?
I will at the appropriate time, but I'd like to hear from questions.
Okay.
I have a motion, please.
It's out, not this time.
Well,
No.
I'm sorry, there's some officers in the room, and I want to know what's going on.
The CHP is charged with security of at meetings with the Public Utilities Commission, and particularly when we have a commissioner with us. And the officers are here to ensure that this CHP is not disrupted in any way.
Well, I don't see any disruption going on, but I have a motion on the videos, and I understand other people do too. And one of the issues we had with the webcast earlier is that it did not comport with the motion that WEM filed asking for a high-quality video. It was a very low quality, and also it was turned off at various points during the hearing, and it did not get turned back on necessarily even when some of the breaks were done, and therefore we missed crucial pieces of the testimony, and it was not possible for people to access it. It had a very old technology, so people had to unload things out of their computer and reload an earlier version of the which made it very difficult, and I object to anyone molesting a person that I know.
First of all, your motion is not appropriate at this moment. Second of all, I'm going to go off the record, and before I do that, I'm going to make it quite clear. There's a ruling in place in the policy of the Commission.
This is a public meeting. We
are going off the record, and if we can't conduct this PhD with any kind of decorum and administrative efficiency, we'll just shut it down and delay Phase 2. So I'm going to go off the record, and I think you need to have a conversation. If that's your associate who intends on violating a ruling of this, you're getting very close to a Rule 1.1 violation. So we're going to go off the record, and you need to get this resolved. We'll take a 5-minute break.
I have a request for a quality webcast that is not broken up when there are breaks. If that is granted, we will consider stepping aside, but we feel that the public has a right to videotape these meetings, and we would like that to be granted by Your Honor.
Please resolve the matter before we begin.
Excuse me, could you tell me who called you into this,
Well, you can do it now.
All right.
Did you get this today?
I did. She barely.
What was their reply?
Well, the judge has not said any reason for me to come up here and resolve it. And wait, please wait until the judge has...
Ms. George, you have one option here, and that's to resolve getting your person out to cease violating the order in this proceeding. That is, the officers are here simply to enforce the orders of the commission. So your interest here is in either having your agent stop violating the order and putting your organization at risk of a Rule 1.1 violation, or you're going to wind up causing this entire PhD to be shut down and Phase 2 being delayed. So these are your choices, Ms. George, and you need to make it. No one who's in the audience gets to shout out points. Parties address...
What? I can't say nothing.
No.
Is this a public meeting?
This is a pre-hearing conference for parties to this proceeding to work on the details of scope and schedule. It is not a public meeting in the sense of a free-for-all for everybody in the public to stand up and say and do whatever they want. This is a working meeting to resolve schedule and scope on the behalf of the parties. Parties are authorized to speak. Now, Ms. George,
Is this public information?
no, sir.
Is it public information?
You may observe this proceeding. You may observe this proceeding. Ms. George, do you wish to take the position that you're willing to shut down this PhD and delay Phase 2 because you're unwilling to conform with the order that's active in this case? Is that your position?
No, ma'am, I
Okay,
want
then
a high-quality video for the public to see.
Ms. George, we have a webcasting contract
Low
that...
quality.
Well, that is not going to be resolved in this proceeding. There is a webcast, and that's the way it is.
Then we need to have it videotaped.
This is not the forum to take that up. You can initiate a rulemaking, you can petition the commissioners if you don't wish to have this webcasting. But we're not going to play this game any longer, Ms. George. You spent a lot of time disrupting and wasting time in Phase 1, and I'm not going to see it happen here. You are disruptive.
I'm sorry, ma'am. I am trying to serve the public. That's my responsibility as a ratepayer advocate. I believe this is a public meeting. I believe it should be videotaped because the webcast was extremely unsatisfactory. And not only that, if Your Honor would at least tell the folks up in the booth to keep the cameras running throughout this hearing until you close it, I would consider asking my associate to stand down. But with the quality that we had the last time, and you are in complete control of whether or not they stop and start the video, I think that is the very least that should happen. And I have no intentions. I mean, we would be...
Ms. George, one point. I'll get Ms. George.
Videotape was operating.
The webcast, the instructions on the webcast are to constantly roll. To the extent they have technical problems, like anyone has technical problems, sometimes the image may drop. But as you know, you've been here before. You've watched commission meetings before, as I have, on the webcast. Sometimes it drops, but it usually does not. And if the commission is taking a break, the camera continues to go. I'm not going to...
It did not continue to go
The audio.
last time. It
Well,
was
the audio.
deliberately turned off when we went off.
Okay, then, we're done debating this. Either the camera leaves or the hearing is adjourned. That's it.
Is this public information?
You have no standing to ask questions here, but our ruling is clear. Either you act on it or the hearing is adjourned. Is that what you want?
I'm a taxpaying citizen.
I don't really care who the hell you are. There's a ruling of this commission, and you have to comply with it.
I don't care who you are.
Yeah.
Yeah.
Officers, can you remove that gentleman?
Go ahead.
Let's go back on the record. All right, please note that we have a court reporter making a record of the proceedings as well as the webcast, so it's important